So we are going to talk about the most expensive legal mistakes that you can make. Feel free to jump in with any questions as we go, or if you've got any comments. I think it makes it a lot more interesting when it's interactive. If you guys have anything relevant to say, go for it. So I'm Rosalyn Gladwin of Gladwin Legal, and I've been running Gladwin Legal for about 8 years now. Before that was in-house at Myer for 7 years, and before that in private practice. So I've seen a lot of the don't do that in my practice experience, and I thought it'd be a really great opportunity with Victorian Law Week to share some of those with you guys so that hopefully you can learn from other people's mistakes rather than making your own. So I thought we'd talk about some of the key issues that tend to pop up in my experience when people are branding and doing IP, designs and patents, who owns your IP, leasing considerations, and shareholders agreements. So there's a few on IP because with a lot of businesses, that's the key value within their business. And one thing, so we'll start off with the importance of IP searches. One thing that clients tend to either gloss over, or usually this comes up when someone's a few years into their business, they've done a whole lot of branding, they've spent a whole lot of money, and they hadn't done the sort of launch IP searches. So what I mean by that is once you've got your business idea, you're thinking about your brand, you've got a brilliant idea, whether it's a product or the actual brand name, do some IP searches, whether you can do them or you can engage a lawyer or an IP specialist to do them for you. So they give you a really good idea of what's out in the market. So if you're talking about a brand, you don't want to have someone send you a letter of demand 2 years in after you've got all your goodwill, you've got all your socials, you've spent a whole lot of money on, packaging and flyers, to then get a cease and desist letter saying, I'm Joe Blow from up the street. I've been operating for 15 years under this brand name and you need to stop. I have a registered trademark. So it can be a real issue. And we've had a lot of clients, well, not a lot, but we get about 3 a year where genuinely somebody has to rebrand their entire business. And to tell you that it's, soul destroying, it's awful, it's gut wrenching when they've had this brilliant idea and they just have to rebrand it. It's not fun. So to save yourself that heartache, once you've got your concept, do your searches. It just checks it off, make sure that no one else already has that brand, so that you can then move on. The other thing is that, if you are infringing someone else's brand, not only could you be liable for, damages or accounted profits, but it's not great for your goodwill. You lose your goodwill when you have to rebrand. And the other thing is that there are instances where two similar brands can coexist. There's certain exceptions under the Trademarks Act. So the problem I see as a lawyer then is if you've got two brands coexisting, then there's an allowed confusion in the marketplace. So if you have, Sally's, Best Donuts and Sally's Hot Donuts, obviously they're going to have a really similar name. Customers are going to get confused, and it's not a great brand proposition for you anyway. So you're better off doing that search in the beginning. Make sure that you've got a really great, unique name that's able to be registered and not going to be subject to an infringement or a rebranding exercise. So things, that obviously that flows onto are your domain names, your packaging, your goodwill. Everything is sort of then touched on by your branding. The other thing is to consider is patents and design. So whilst I don't do any patent work and I do a bit of design work, it's certainly an area that's really important, because if you have an idea that's able to be the subject of a patent or design registration, you can't put the toothpaste back in the tube. Once you've gone out, you've marketed it, you've told people about it, even if you haven't sold any items, once it's out there, you cannot go and get a patent or a design registration. There are some certain unusual and sort of very technical exceptions to that, but I certainly wouldn't be advocating relying on them. I would as an initial, step in your business, make sure you do those, because once you've done it and you've gone and sold it, you can't go back and get a registration. There are different types of trademarks, there's different types of designs, there's different types of patents, and you don't always have to go through the full process before you disclose. The key is actually just to getting your lodgement in, getting the clock ticking on your application, and then you can go off and market it. Another important aspect is about who owns your intellectual property. So IP ownership, people assume that they always own everything they create or that their business creates, and that's not always the case. So it's really important to look at your employment agreements, your contractor agreements, drafting agreements properly so that you've got clauses that give you that ownership. So an example is, I had a client come to me, they had a trademark designed and they wanted to then go and adapt it. The designer came back to them and said, you're not allowed to adapt it. You don't actually own that trademark. So the agreement that they had signed with the designer was that the designer owns the IP in their trademark. So this business is operating a business and doesn't actually own its trademark. So it's really important to check agreements with especially with your contractors, to make sure that you own it. And there's, little tips and tricks we can put into the agreement so that if you don't get ownership, you can at least get a license to use the agreement. So, have those discussions with the people you're engaging up front so that they don't come as a surprise later on, because that's when disputes arise. So talk to them, get clarity as to who owns the IP, and then document it properly. So we'll chat about leases now. There's been a lot of discussion over the last couple of years about leases. They've come up a lot in terms of the rent relief clauses and the COVID issues. And I think a lot of that has brought to the forefront issues that people have had when they're assigning and transferring leases or taking over leases, because there's been a lot of movement in the physical market over the last 2 years of people leaving shops. Someone else, comes in and takes over the lease. So an example I had 2 weeks ago was a client had said, we wanted to save a little bit of money. We didn't get you to look at this assignment agreement a year ago that we entered into because it was just a short little 1-year agreement. It's now going to cost them $100,000 to make good a premises that they didn't fit out. So in this example, there was, party A, let's call it Bob's Burgers, had a shop. Sally's Donuts moved in for a year to take over the last year of the lease because the burger shop wasn't doing really well. Sally needed a new spot, so she's come in. The lease has a clause to say that the assignee, so Sally, has to make good, as in take out all the fit out, all the fixtures, turn the shop into a bare shell for the landlord at the end of the lease. So just because Sally is the holder of the lease at the end of the term and her assignment agreement says that she's going to do that, she now has to spend about $100,000 removing all the burger, the kitchen, the grill traps, the counters, the cabinets, the chairs, redo the flooring, paint the walls. It's going to cost a fortune, all because she wanted to save $1,000, having a proper review or, whatever it might cost of that document at the time. So I'm not necessarily saying, everything you sign should be reviewed by a lawyer, although it should. I think it's really important that you're just aware that there are some really expensive issues that can pop up in certain agreements, and just be alive to them, and also have the discussions at the start with the landlord, with the assigner, or the person who's giving you the lease. The other thing is rent review and renewals are really important. Yesterday I was reviewing a lease and it had a clause to say that there was going to be a CPI review and a market review, but if the reviews resulted in a lower lease, then the lower lease was not to apply. So, we're pushing back on that. So there are certain clauses with rent renewals and reviews, even if your commercial schedule has the correct rates and the correct review. The key is looking at the detail of the clauses. Again, lease negotiations, have the discussions up front. Make sure in the letter of offer that you're not signing a blind clause that says, I will sign your lease, whatever the terms are. Often I see those clauses, and then when someone comes to negotiate a lease with me, they've already signed something that locks them into a particular lease. So it's really important to kind of step back and check the detail of the offer letter. So that really goes to know what you're signing. Make sure you're really clear on what the terms are, and make sure it's well drafted. So make sure if you can't understand it, don't sign it. It should be plain English. It should be something that anyone picking up the document can understand. So shareholders agreements are critical. Often you see issues where, we sort of say they're for divorce, not for marriage. When everyone's going into the arrangement, everyone's happy, everyone's on the same footing, everyone's generally on the same page. By the time someone has a dispute about the shareholders' arrangements, if you don't have agreement at that point, a documented agreement, then it's already too late. So a shareholders agreement, they cover off things like who owns what part of the company, who has what responsibilities in running the company, what the business function is, what the business is allowed to do, who can make decisions, who can operate bank accounts, who can hire staff, that gets, X dollars a pay. So when we're drafting them, we go through a whole list of items that each shareholder can agree on, whether the board has to agree, whether shareholders agree, what kind of level of voting. So it's really important to set out your rules of your gameplay from day one. If you don't, the problem is when you have a dispute later on, you don't have any rules. You're then stuck in an agreement with someone who's obstructive or stopping your business. So an example I had that I've got at the moment is a client who has a shareholder. The agreement is, they do have an agreement, but it's very poorly drafted. It's about 3 pages long. It doesn't go into a lot of the key concerns I would like to see. It's a single director. So you've got 15 shareholders, and there's this one director who's not agreeing to distribution of profits, not agreeing to the budget. So we've had to get, a little bit creative about how we manage this process, but it basically means that all the investors who put, hundreds of thousands of dollars into this business, it's going really well. It's generating, a truckload of money for them all, and it's growing brilliantly. And they've got this one person who's just, basically hamstringing the whole business. So having a shareholders agreement would otherwise mean that he wouldn't be able to do that, because other people could automatically appoint someone to the board, or certain things could be decided by shareholders rather than this one director who's holding the company to ransom because he wants a bigger distribution or because he wants to sell his shares at, a higher price. So people, I guess, can use that power to wield it in ways that are not beneficial to the company, and there's not a lot you can do. So having a shareholders agreement allows you to set the rules from day one and allow you to be really clear about who can make what decisions, and if you're not happy, how you get out, how you get your money out, or how you get the other person out. At the end of the day, most businesses, most shareholders are going to end up splitting, whether, it's harmonious and they both sell out, one buys another out, God forbid one dies or gets sick, the agreement can deal with all of those things. So they're the kinds of things that we see where people, make mistakes, or things are overlooked or they're glossed over, and it ends up costing a lot of money down the track because you're stuck with a situation where an agreement could have protected you and it doesn't. So just to recap, I would suggest, in any business, making sure you do your IP searches, making sure you do, trademark, design, patent searches, making sure you protect your IP. And, something else that comes to mind with that is not just in making sure you own your IP, but also making sure that employees, contractors, people that you deal with can't copy your IP or compete and work against you rather than with you. Making sure that your lease is really clear and protective, and being really clear and making sure you've got a great shareholders agreement. So we're a bit shorter than time, but if anyone's got any questions, feel free to jump on. Feel free to, email me any questions you might have. I hope it's been helpful just to highlight some of the key tips and tricks in your business and hopefully save you guys a bit of money down the track because you're not going to make these mistakes. Well, I think, no questions, but you've got my details, so feel free to shoot me an email or get in touch. More than happy to get back to you. Thanks for coming. Bye.